हाय फ्रेंड, नमस्कार। जीएसटी अपडेट में आपका स्वागत है। उड़ीसा हाई कोर्ट ने एक जीएसटी मैटर में फेक आईटीसी बोगस आईटीसी क्लेम के मामले में एक चार्टर्ड अकाउंटेंट को बेल दिया है ऑन द फर्निशिंग ऑफ द 50 lakhs बॉन्ड्स। तो आइए देखते हैं केस का फैक्ट्स क्या है। ये जो केस है जजमेंट डेटेड 11 जनवरी 2022 का है। इस केस में पेटिशनर जो है वो चार्टर्ड अकाउंटेंट है एंड अलेज ऑफ द यूटिलाइजिंग एंड पासिंग बोगस आईटीसी ऑफ 319.64 crore that included claim and availment of the bogus ITC on the basis of fake invoices by creating and operating 13 fictitious firms. It is made to reveal from the record that the basis of confidential information and investigation concluded by the Deputy Commissioner of the Cell Tax and Enforcement Unit, Sambalpur, report was submitted against the petitioner for having committed offences under Section 132, subsection 1B C I of Orissa GST Act, which was registered as PR number 01 of 2021-22. In this case, with the satisfaction being arrived at during investigation, the petitioner was arrested in terms of the section 69 of the Orissa GST Act and was forwarded to the court concerned on 2nd September 2021, and since then he is in the judicial custody. According to the opposite party, state the petitioner in collision with the other forged certain document for obtaining GST registration in respect of the 13 fictitious business entities, and in course of the investigation it was ascertained that such establishment were not in existence. It is alleged that the so-called proprietor of the fake firms never issued any authorization to anyone or the petitioner who misutilized their identity document for the purpose of registration, and in respect of 10 remaining firms, the proprietors are still untraceable and residential addresses declared found to be fake, and therefore steps are presently being taken to trace them or to ascertain the extent of the tax fraud. आइए देखते हैं इसमें जजमेंट में क्या कहा गया। As far the allegation is concerned, the petitioner, being the chartered accountant, was involved in the creating and making fake business entities operational in order to facilitate availing bogus ITC. As per the material on the record, the petitioner allegedly obtained GST registration, vice the fake business concern in the collision with the other accused person by utilizing and forging the personal identity document of so-called proprietor. The nature and extent of the involvement of the petitioner with regard to the alleged transaction is clearly evident and figure out from the materials on record. So far the offences under section 132 of the Orissa GST Act is concerned, it is in relation to the GST fraud alleged to be for an amount of 319.64 crore, wherein the petitioner is said to be involved by creating and operating fictitious business entities in the name of the person having no means. As a consequence, bogus ITC was availed by the business establishment for whom he worked as a chartered accountant with the allegation of the joint liability. I regard the plea for the release on the bail. The petitioner, the relevant factors are to be examined as to if in the event it is being allowed, what repercussion it would have to be for the purpose of inquiry and trial. The petitioner happens to be a CA and his service was availed by the alleged business concern. Whether it is a case of the petitioner facilitating the bogus ITC being availed is to be dealt with the adjudicated upon during and in course of the trial. The GST authorities have managed to find or the alleged fraud being perpetrated towards availing fake ITC by creating bogus business entities, and it appears to be an act which apparently makes all the accused person jointly and severally liable. TS to be offence punishable under section 132 subsection 1 of the GST Act. It prescribes a substantive sentence of 5 years in the maximum having regard to the nature of involvement and the specific role which is claimed by a CA and his period of the detention of 4 months, and the fact that sufficient materials have already been collected, and as the prosecution now primarily depends on the documentation and related evidence, and for that tampering with the evidence seems to be remotely possible. The court, being aware of the settled position of the law applying to the subject matter, it is inclined to release the petitioner on bail, subject however to a stringent condition to as stipulated herein as below. Accordingly, it is ordered in the result application under section 439 of the CRPC stands allowed. As a consequence, the petitioner is directed to be released on bail on furnishing a bail bond of the 50 lakhs with 2 solvent sureties for the like amount to the satisfaction of the learned court below in session over the matter, with condition such as he shall not induce, treat or terrorize any of the material witness while on bail, shall not exercise any kind of the influence or pressure vice versa the prosecution witnesses to be examined during the trial, and thus not to tamper with the collected evidence in any manner whatsoever, shall not involve or indulge in any such manner similar kind of the nefarious activities, shall surrender his passport if he has any before the learned court below, and shall not leave the jurisdiction of the court without his prior permission. Thank you so much for watching this update. In case any of the above condition are violated, it shall forthwith entail cancellation of the bail granted to the petitioner. तो यहाँ पर bail दिया गया subject to the furnishing of a bail bond of the 50 lakhs rupees. तो यहाँ पर fake ITC claim का मामला था. Thank you so much.